Yes, good evening to everybody, to the students of the Advanced Private International Law that we dealt in the last class, the recognition and enforcement of the foreign judgment. And today class that we are going to deal the matter with the international instruments, how the international instruments will make the recognition and enforcement of the foreign judgment. Yes, now for my to me that you'll please read what I posted on the screen so that we could know each other that you are hearing me and I am hearing you. Yes. Unmute and read.
Conventions. Good evening to the students of APIRO. Conventions are international instruments which establish obligations and sanctions inferior to perform obligations set in agreement by states. For a state to become part of international agreements, need to sign and ratify a convention. But other states depend to their mode of reception of conventions. International laws automatically form part of domestic laws. Sanctions on breach of international instruments include economic embargoes, barrier, termination of diplomatic relations between states, and forceful military invasion, which rarely happens.
Yes. This is the gist of the how far the international instruments will play the role in the private international law. So whatever the international instruments are there, they are nothing but conventions, we'll say. We don't say charter because charters are made by the UN and the treaties are made by the UN agencies. And here the conventions, it is the agencies under the sanction of the UN, they make it out. And the people, means people in the sense state, those who are party to the convention, they have to follow the convention's regulations and rules, and they have to ratify in their municipal laws also. So that is the conventions are international instruments which establishes obligations on whom? On the states. Which states? Member states. For which conventions? Those who are member state in that particular convention. And sanctions in failure to perform obligation. Suppose if they could not follow the conventions in the domestic law, there is a sanctions should be there. What type of the sanctions? Economic embargoes, barriers, termination of diplomatic relations, states, transport, even forceful military invasion also will be possible at the time when they will break the conventions. Who? Member states. So to perform the obligations set in agreement by the state, because in the conventions, every state, those who are the members of that convention will have to follow the norms or rules and regulation framed in the convention. Did you get my point? Say yes or no.
Yes, sir.
Yes. For a state to become a part of international agreements, suppose if any state wants to become a part of any agreement or any convention, it need to sign for the signatory. After signing, again ratify a convention. What is meant by ratify a convention? Yes. If you know it, you tell me. If you don't know it, just yes. Please continue.
To Parliament.
What is it? Repeat.
That convention or to be passed by the Parliament.
It will be domesticated, in other words. It will be domesticated in their municipal laws by the parliament, legislation, whatever it may be there. If it is the central government, parliament. If it is the state government, legislators. So, but other states, depends to the mode of the reception of the convention. So other state also will take the norms of the conventions, those who are the member, and each state will oblige to the other state. Each state will be obliged to the other state. Means each state should have to give the respect to the recognition and enforcement of the foreign judgment, those who are the members. So international law is automatically form a part of domestic law. At the time, what will become? When you ratify it, international instruments will become a domestic laws. So sanction on a breach of international instruments include, we already told you, what are the sanctions? If any states breaks the rules and regulation of the convention, please tell me, what are the sanctions?
Various termination of diplomatic relation between states.
Good. Economic embargoes, economic barriers, and even the transport, and the last, forceful military invasion also. Is it
Can I ask
clear?
a question, Prof?
Is it
Can I ask a
clear?
question?
Yeah, the
It is
question
clear.
is,
Can
what
I
are
ask
the
a question?
sanctions?
No, can I ask a question?
Yes, please.
What do you mean by the term economic embargoes?
It is a business transactions. Business is nothing but economic, is it not?
Yes.
Okay. For more clarification, let me see what is that. Oh, again, read it is gone. It is fully covered over here. Okay. So, for more clarity, I given you economic embargoes means business transactions. So now let us see our study. What comes first? Recognition and enforcement of the foreign judgment, or enforcement of the recognition of the foreign judgment? Which is the correct sequence?
The first one.
See,
Recognition and enforcement.
it is a recognition first, then only enforcement will come. First, what it comes? Recognition will come. So, the concept of the recognition and enforcement of the foreign judgment under the various conventions, of course, is an article written by Johnson Yahya. So, when you see the introduction, what is a foreign judgment? Anyone? What is meant by foreign judgment?
It is the judgment of a foreign court.
It is a judgment given by declared by the foreign court is a foreign judgment. What is the foreign law? Suppose it's a Tanzania.
The law
What is the foreign law to the Tanzanian?
Kenyan law.
The law which is other than the Tanzanian law is a foreign law. For instance, Kenyan law, Ugandan law, Indian law, English law, American law. So when you say the definitions, when you say the answer, you should be very much particular. What we have to say? A foreign law is that law which is other than the Tanzanian law for the Tanzania people. Is it clear? Example, you can say that Kenyan law, Ugandan law, and other law. So, a foreign court means a court situated outside the country and being not established by the authority of the government to which a judgment is being enforced. So, suppose the Tanzania, where they want to make the enforcement of the foreign judgment, at the time, the judgment of the other country is nothing but a foreign court judgment. For the foreign judgment to be valid, what the conditions is there? the foreign court rendering such a judgment must be competent to try such a suit. That means the judgment which is declared or delivered by the competent court, there is a must condition, not only as regards to the pecuniary limits of its jurisdiction or the subject matter of its suit, but also with the reference to the territorial jurisdiction. Of course, whether it is a territorial jurisdiction would be there in a particular country or not. When you say the territorial jurisdiction, and there the comes over there, and the competence of the jurisdiction of the foreign court is to be judged not by the territorial law, but the foreign state might be the rule of private international law. When you say the territorial, for instance, you can take the Kenyan law. If the Kenya will decide the case in the jurisdiction of the Kenyan country. Am I right? Geographical area of the Kenya. It will be decided. Am I right? Say yes, sir.
Yes.
Yes. But when you are using that country law in the Tanzania, the jurisdiction varies, no? There is no question of jurisdiction will count there. But what we will count there? We count the rules of the private international law. Because of the treaties, conventions, etc. There, the jurisdiction, we don't consider the territorial law of the foreign state, but the rules of the private international law will come into the picture when the matter comes to the jurisdiction. Did you get my point?
Yes, sir.
Yes.
Foreign judgment is a judgment with a foreign element which is enforced by another court, differ from that gives the decision, but it operates outside its jurisdiction. Suppose the judgment given by the Kenya, but it would be operated in Tanzania. How? Because of the private international rules. If there is no treaty also there, if the justification would be there, the Tanzanian court will implement the Kenyan judgment. Are you following me?
Yes, sir.
Yes.
Good. So now the recognition of the foreign judgment occurs when the court of one jurisdiction, see, Kenyan jurisdiction, accepts the judicial decision made by the courts of another foreign country. If the another foreign, for the Kenya, what is the foreign country? Tanzania is a foreign country. Uganda is a foreign country. Even that jurisdiction or that court and the jurisdiction and issue the judgment in substantially identical terms without rehearsing the substance of the original lawsuit. Why we are doing so? The answer is the same facts. Why we should be tried again in the court of Tanzania? Why not directly we can use the judgment of the another country, foreign country or foreign court? I gave an example. 2 into 2 is 4. Am I right? Say yes.
Yes.
Yes, sir.
Is it valid only in the Tanzania? It is valid in the Kenya.
Both.
It is valid anywhere in the world, you can say, not only in Kenya. Am I right?
Yes.
Yes, sir.
When such a matter would be there, why we have to make the multiplication and doing all the work, equations? We need not to do the equations because already we know the result 2 into 2 is equal to 4. So we need not to prove it again because the equation is acceptable and the competent court has given it. So that is the means of it. Thus, once a foreign judgment is recognized and a party who has successfully in the original case or suit can then seek the enforcement in the recognized country. Suppose if that a judgment given by the Kenyan court, by the competent court, by following the jurisdiction, not jurisdiction, by the substance and the pecuniary jurisdictions, at that instance, if it is enforced in Tanzania, again we need not to prove it, the whole fact of it, because the facts are the same. So that is the term without rehearsing the substance of original lawsuit. As it is, we can use it. So once the judgment is recognized, the party who was successful, we can implement where they want to implement the judgment. So for example, if a foreign judgment is a money judgment, a money suit, and the debtor has properties in recognizing the jurisdiction, the judgment creditor has access to all the enforcement remedies if the case had originated in the recognized country. For instance, the Kenyan court has decided what? Yes, the judgment debtor has to give the amount to the creditor. At that instance, suppose the creditors, the judgment debtor would be there in Tanzania. At that time, he is having the assets in Tanzania. The same foreign judgment of the Kenya can be implemented over here because it is a money suit and he is having the property in the Tanzania. So Tanzania government as a moral responsibility will take it and see that it will be recovered from the debtor. What? That money. Which money? That money which is passed by the Kenyan court to be given to the creditor. So that is the same. A judicial sale, attachment of assets to the judgment garnishment. Even the attachment could be done if it is having the properties in the Tanzania. Why? Suppose if it doesn't have the properties in Tanzania, at least suppose if he is an employee in Tanzania, let his salary will be attached, but not total salary. Each month some cuttings would be there, attachment of the salary. And they will give the garnishment. You know what is meant by garnishment? Yes?
No.
A
No.
third person,
To see
a person,
Count.
a third person will have given such a right to cut his salary of the employee. That is called garnishment. A third person, for instance, a judgment debtor would be there and he is an employee. The court will give the order to the employer, please deduct equal so-and-so installment, easy installments of that amount from the salary. So the court gives the direction to the employer. So here the employer is a third person and that is called garnishment. Is it clear?
sir.
Yes. And if some other form of judgment is obtained such as that affecting the status, granting the injustice relief, recognize the court will make whatever order which are appropriate to make the original judgment effective. Suppose the judgment is given in a wrong way. Yes, that cannot be implemented in the Lex 4E. Another point also I made it. Suppose the Kenyan judgment is in contravention with the statutes of the Tanzania, it cannot be recognized and enforced. Suppose it is against the Tanzanian policy, then it cannot be recognized and enforced in Tanzania. What is the third point? Statute is there, policy is there. What is the third? If it is against the...
Customs and ethics.
No, that is a policy, ethics, morality will come all in the one way. Constitution.
Constitution.
So three are there. One is the statutes, enactments, another is the policy, another is the constitution. So now let us say enforcement of the foreign judgment. Foreign judgment is enforceable in most common law countries. Tanzania is a common law country or not? Yes?
It is.
What about India?
It is.
How could you say which are countries are said to be the common law countries?
England, India.
Those which are colonized by England.
No, those who are ruled by the English law. those who conquer the countries and rule there, those are all come under the common law countries. So that is the definition we can say. That countries which are ruled by the Queen Elizabeth or whatever the parliament would be there. The government is there, and that government, English government or England, the ruling, the other countries, they all come under the common law countries. So decision of the foreign court can only be enforced by proceedings in execution. Suppose if you want to execute that foreign judgment, if you want to use it, you have to make an application to whom? Of course, foreign ministry comes, later the embassy comes, embassy will write to the external affairs will see that, give the order to the apex court, generally not a court of appeal, but the high court. So the person was to make a notice to the high court where he wants to implement the foreign judgment. So the enforcement of foreign judgment, a decree holder required, a decree holder means who got the in favor of his him, a decree holder required to register such a decree before a judicial system of recognized country where the judgment will take effect. Suppose if they want to implement in Tanzania, at that instance, he should have to register in the high court. What? He got the decree by the so-and-so court, and hence he can make an appeal to the high court. The high court will take it as it is. It will observe whether the judgment is according to the in contravention with the state enactments, whether it is a contravention to the Tanzanian policy, whether it is a contravention with the constitution. If any contravention should be there, the Tanzania will not accept the
Foreign judgment.
The foreign judgment. Yes. Can you
Foreign
read?
judgment.
Yes. And this Raymond Dance and Tenesco, we already read it. This is the first case law in the arbitration where recognition and enforcement of the arbitration will be held in Tanzania because ICC tribunal, which is given the judgment in favor of the Richmond Dons, and they said it is agreed by both the parties. Hence, if you want to really agreed by the such a decision, you have to prove that there would be a mistake happened, or there would be a coercion would be there would be illegality would be there, then it can be considered. Otherwise, it cannot be considered. That the High Court of Tanzania has given. But again, the Tenesco appealed the Court of Appeal. The Court of Appeal, what they said? Court of Appeal, what they said? Please give me the answer. Unmute and give me the answer. If you don't know, just pass on. You tell me.
The Court of Appeal was challenging the legality of the award from the ICC.
No. It is considered, they said, is whatever the High Court is given, it is right. So uphold the judgment of the High Court, because once the parties are agreed over there that if any dispute would be there, then ICC, they agree to the ICC dispute, and where the contract was breached by whom? The contract, Tenesco. But at that instance, the High Court will say no, because it is given and you agreed and it is validly given, and they followed all the norms of the arbitral award. All the norms of the arbitration award. It means there would be a jurisdiction, there would be a agreement between the two parties, and the rules will be followed, and the judgment, the trial award, we don't say judgment for the tribunal, we will say award. The tribunal given the award, there is no discrepancy, there is no illegality, there is no coercion, there is no unlawful. At that instance, nobody could interfere it, and hence that would be the final award. So who won the case?
Loans.
Dons. Of course, damages will be paid with the Tesco. You need not to remember the figure. So 9,000 USD, Nini, Nani, because you say the damages is paid by the Tesco to the rich man. So an agreed defendant large days, this already we read it. High Court has given ICC challenged and so and so forth. So it has been made in a pursuance of the agreement of the agreements because it's a condition they agreed valid under the which it is governed there, and all the points they have mentioned because they agreed and there is no illegality. The governing law they have followed. Which law? The arbitration procedure they followed, and it is becoming a final in the country. It was made over there, and because a competent court after that one tribunal, there is no other thing. So hence all the conditions will be followed over there. And in addition, Arbitration Act also clearly says United Republic of Tanzania incorporated the Geneva Convention. So now the convention has come over there. What they said, the Geneva Convention, the Tanzania is not only the signatory, it is ratified also. And the convention is a protocol to its own provisions, which means it recognizes and enforces the award from an alien state within the scope of the Geneva Convention and protocol. Because the Richmond also hailing from that country, it also be a member of the Geneva Convention, and the Tanzania also the member of the Geneva Convention. At that instance, if any arbitrate award is passed by the one in one country or one court in another country, and should be given a respect, because principle of the private international law principle will be used over there. What is the doctrine? The doctrine of there is a doctrine of we can say, what is that? We have to give the respect to the
Principle of
decision
comity.
of one court, and the same respect we have to give to the other country also, because they give the respect to it. What is that? The doctrine? Can you tell me?
The principle of comity.
The principle of comity. Because you respect our decision and we respect your decisions. Is it clear? That is called reverence.
Yes.
Now let us see the Convention on the Recognition and Enforcement of the Foreign Judgment, the Hague Convention. There are so many conventions of the Hague are there, but in different field. But here is the Hague Convention on the Recognition and Enforcement of the Foreign Judgment in civil and commercial matters. And the TENESCO Richmond Downs, what is the transaction there? Is it a commercial transaction? Is it a civil transaction? Yes?
I believe it's a commercial transaction.
It is both. It is a civil, because it's a breach of contract, it is a civil, and it is a commercial matter. So it will be the judgment, the convention requires the contracting states to recognize and enforce the judgment given in a civil or a commercial matters in other contracting states. Who is the one state? Tanzania. Richmond from which country? He is from England? Richmond. I think he is England, because ICC they say England. Are you following me? Subject to
Yes,
the
sir.
correction. Yeah. And England also member of the Geneva Convention, and Tanzania also member of the Geneva Convention, and hence when once tribunal is passed in another country, should be given respect in the another country, one country, because they are the members of the country. So judgment of the convention covers the wide scope of the recognition and the enforcement of the foreign judgment as per the convention. Which convention? Hague Convention. In what? Civil and commercial matters. Judgment is any decision on the merits given by the court, including both the money and non-money. Judgment conventions, a party who is the holder of any judgment within the scope of the judgment or judgments convention, and he or she is entitled to enforce such a judgment to any country which is a signatory of the judgment convention. So signatory plus, of course, when you say the signatory, automatically that you have to ratify it. If you don't ratify it, they will take Sanctions are there. Am I right? Of course, in
Yes.
some places, they will only the signatory, but they don't ratify it. But merely the signatory, that doesn't mean that you will be the member of it. And they will sometimes discard you also. So not all civil and commercial judgment falls within the scope of judgment conventions. Matter relating to insolvency also comes over there. The validity of the companies and the decision of the organs. Of course, these are a different aspect of it. Intellectual property will not come and privacy will not come, and even antitrust matter are not subject of the recognition. Even the insolvency also we don't consider it. Matters related to insolvency, the validity of companies, no, it will not be come under the civil and commercial matters. Of course, they don't interfere in that matter. So arbitration and related proceedings and judgment for damages don't compensate a party of actual loss, a judgment for the exemplary punitive damages. See, naturally, in the law of contract, there is no exemplary and punitive damages. It is only the compensatory damages are paid, are exempted from the recognition and enforcement of the judgment conventions. And where the punitive damages are awarded, in the law of contract, the exemplary or the punitive damages are not awarded. What is awarded? Only compensatory will be awarded. But if you want the special damages should be awarded, it should be specific provision would be there in the contract itself in the beginning. So where the punitive damages are awarded? Please tell me. Where the exemplary damages are awarded? Tort. Are you following me? Say yes.
Yes, sir.
In tort, it will be
Yes.
available, but both contract and tort, both are civil laws. Of course, in some places, tort is a criminal law, like a defamation, public nuisance, private nuisance. At that time, it is both the civil law, the civil, offense as well as the criminal offense. Please mute when you speak. Open because I'm getting the sound. Mute. I don't know why you did not mute. Who did not mute? I can say from here. Of course, now everybody is muted at the time that somebody did not mute. So the foreign judgment will only be the subject to recognition abroad if he affects in the jurisdiction in which it was given the state of the origin, and it will only be enforced abroad if it is enforceable in the state of origin and not otherwise. Then the question comes over there. A member state would be there, number one, and it will be given in with following all the norms of it, then only it will be considered in other country. Otherwise, it will not be considered. Why it will be considered? Because they are the members of the. Tell me. They are the members of the Hague Conventions in the matter of the civil and commercial matters. Okay, now next, can we read the next convention? Anyone can unmute and read, which I am highlighted here. See, the cursor is here. I don't know. One day you don't know the cursor. Nimestuka. Of course, not necessarily that you should have a computer knowledge. Do you know at least now the cursor? Yes?
Yes, sir.
What is the cursor?
Yes.
Can you tell me? At least can you tell me the cursor spelling? Please. Can you tell me the cursor spelling? Anyone? Anyone? Okay, I will tell you, don't worry.
I'm having.
I will tell you, don't worry. CURSOR, cursor. See, this is the cursor. It is having the different shape. Of course, I don't ask what is the mouse and what is the USB, what is the microprocessor, what is the external inputs, what is the internal inputs. These are all one should have to supposed to know it. Okay, let us come to the point over. Can you read this convention? Anyone can unmute and read.
The Convention on
The
the
convention.
Recognition.
Only one. You decide one. See, a person who read once, he need not to take the chance. He should give the chance to others. Raymond, you give the chance to others. Yes, read the. Other than the Raymond. Read.
What part? What part, Professor?
Read this. See cursor, where I put the cursor. Did you see the
The
cursor?
convention on the, yes, I'm seeing the cursor.
Read.
The convention on the recognition and enforcement of foreign arbitral awards, New York Convention, agreed by states in the United Nations Diplomatic Conference on 10th June 1958 in New York and entered into force on 7th June 1959. The convention requires courts of contracting states to recognize and enforce arbitral awards from alien arbitral bodies or arbitrators. Widely considered the fundamental instrument for international arbitration, it applies to arbitrations that are not considered as domestic awards in the state where recognition and enforcement is sought.
It is nothing but it is another convention. What is the name of the convention? New York Convention. Regarding what? Recognition and enforcement of the foreign arbitral awards. Then it is signed by the parties, and the Tanzania also one of the party for that one. If I not be mistaken, please subject to the correction. So who are the members of this New York Convention at the time? A one country decision, I mean foreign judgment, can be recognized and enforced in the other country also. So I need not to give the full explanation because there is the same gist will be given. Of course, they have given the articles. You need not worry about the articles. What you have to say, even the New York Convention also will recognize the, what did it recognize? Foreign judgment. And all the members, those who are convention, they should have to obey it. Suppose if they don't obey it, what would be the punishment? Suppose the one of the state that did not obey it. What would be the
Economic
punishment?
embargoes,
Sanctions. That is called economic embargoes, diplomatic relations, transport, and
military
even
invasion.
in the case of very invasion of the military also. Okay, next convention. Can anybody will unmute and read? Those who did not read, for them that you had given the chance. What you have to read here? I am showing the cursor. The cursor I am showing that read that paragraph. Yes. How many are present? Let me see it because I want to see. No, the quorum is present. Dorcas, have you read it?
The convention.
Please proceed.
The Convention on Jurisdiction and the Convention on Jurisdiction and the Enforcement of Judgment in Civil and Commercial Matter (brackets in EU-EFTA relation) close brackets. Parenthesis. This convention applies to civil and commercial matters, whatever the nature of the court or tribunal. It is limited to matters relating to revenue, customs, or administrative matters. The convention do not also apply to the status or legal capacity of natural persons, rights in property arising out of a matrimonial relationship, wills and succession, bankruptcy, proceedings relating to the winding up of insolvent companies or other legal persons, judicial arrangements, compositions and analogous proceedings, social security and arbitration.
It is also giving the same thing. What is civil and commercial matter? Which one? It is the convention of jurisdiction of the enforcement of the matter, that is the European Union. It is about the European Union Convention. It is also given, but the only thing, it also will not apply. The convention don't also apply to the status or a legal capacity to the natural persons. Rights in the property, it cannot be, it comes because there's a property disputes. And matrimonial relations, it will not come because it is a different matters. It is not a commercial matter. And wills is not a commercial matter. Succession will not come because it comes in the different aspect. Insolvency also not covered over there. So winding up the insolvent companies also not covered over there, but only the contractual matter and money suits are entertained over there in the European Union Convention. In the exam also you have to write the same thing. Next, Geneva Convention. Yes, Raymond, you can read now. Geneva Convention.
Geneva Conventions on the Execution of Foreign Arbitral Award. Article 1 of the convention provides that
You need not to worry about the article because article says many things, but the gist is it will follow only the arbitral awards in the civil matters are concerned, because it says many things, because you cannot remember all the article. Am I right? Am I right?
yes, sir.
Because
Yes.
any convention, if you take the private international law, it is only the civil matters are covered over there. No matrimonial matters, no insolvency matters, no property matters. Are you following me?
Yes,
Because the
Professor.
rules and regulations are the same. Rules and regulations are the same. So the convention established the ground for the execution of the foreign arbitral award in another jurisdiction, but among the high contracting parties to the agreement, all arbitral awards covered by the protocol on arbitration clauses are subject to the recognition and enforcement among the member of these conventions. So it will be only applicable to the among the members states of these convention. Which convention? Geneva Convention. For what matters? Civil matters and commercial matters. See, the way I am speaking, I am speaking like a lion voice. And when you are read Dorcas, you read, this convention establishes the ground for the execution of the foreign arbitral award in another jurisdiction, but among the high contracting parties to the agreement, all arbitral award covered by the protocol and arbitration clauses are subject to the recognition and enforcement among the member states of these conventions. No. This convention establishes the ground for the execution of the foreign arbitral award in another jurisdiction, but among the high contracting parties to the agreement, all arbitral awards covered by the protocol and arbitration clauses are subject to the recognition and enforcement among the member states of these conventions. That is the style of reading. You make stress, you take the pause, you make the pitch high, you make the pitch low, not the same pitch. Did you get my point? Say yes.
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 What is meant by
Yes.
pitch? I said pitch. What did you understand by pitch? P-I-T-C-H, pitch. Anyone? What did you understand by pitch? Rhythm, rhythmatic manner. The sound, up and down. The pitch should be varied. That's my point. Okay, let us the last point. Multilateral Investment Guarantee Agency, MIGA Convention. MIGA, MIGA Convention. MIGA is it a, what is abbreviation MIGA? What is the abbreviation among the four types of the abbreviations which I told you? Yes. In abbreviations, four type of the abbreviation I said, initialism, acronym, shortening and contraction. Which one it is? Please tell me, time is going to up. Acronym. This also says the same thing. International cooperation in the economic development to foster the contribution to such development of the foreign investment in general and the private foreign investments. The MIGA also says the same thing. Thus, the supplementing the activities of the International Bank for the reconstruction of the development and the bank's international finance corporations, and it deals about the financial matters, other international development of the finance institutions, it will cover over there, but the money matters. Recognition and enforcement of foreign judgment and the MIGA conventions, we need not worry about the article 56 and 57 of the conventions, but what we are considering is, it also recognizes the enforcement of the foreign judgment. Each member shall recognize an award rendered pursuant to this article as binding or enforceable within the territories. If it were a final judgment of the court, that member, the execution of the award shall be governed by the laws concerning the execution of judgment in force in the state in whose territory an execution is sought, shall not derogate from the law of the force relating to the immunity of the execution. That means whatever the court is pass the award, it should be a competent court, and should follow all the norms of the arbitrate award, and there is no any discrepancy would be there, and the existing law in that country also will be strictly followed over there. Then only such a conventions will be taken into consideration for the recognition and enforcement of the foreign judgment. So how many conventions we read now? Anyone? How many conventions we read now? The Hague Convention. Next, the New York Convention. Next, the EU Convention. Next, MIGA Convention. Total, how many are there?
There are 4.
4
One is
conventions.
Hague, number 1. 2 is New York. 3 is EU. And 4th one is Geneva. And the 5th one is MIGA. Total? 5.
5, sir.
See, conclusion we already read. Where you read the conclusion? Can you tell me? This conclusion we already discussed. Where you discussed this conclusion? Because at any time it will be stopped. Time is up. At any time it can be stopped. Where did we read this conclusion? Can you tell me? See, Rahman, you read this in my.
Yes,
See,
Professor. At the big,
you read in my poster.
yes,
Do you know-
Professor, I remember.